So as Kristen was mentioning, we hope to give with this brief presentation a contribution to the current debate around the Fondo Social de Protección de Venezuela. This is an ongoing topic in the international community, something that we have been working more and more at CIFAR. The name itself is a bit complicated. We are still looking for a more attractive one. Return of assets through third parties, through independent parties, or indirect returns. This is, of course, in the topic of asset recovery, the last part of the return process once the investigation, the freezing, and the confiscation has taken place. Basically, when 10 years have passed, the negotiations usually start with the discussion about how these assets should be returned and how they should be used. And this is also relevant for not only the criminal aspects of corruption, but also for the compensation, as we have been discussing today. So just to give you a few ideas on what these cases are, these are, as I said, returns or international returns cases that involve the presence of a third-party agencies such as international organizations, and they are usually used for the purpose of solving specific situations, such as when in the country of destination there is a difficult context, such as human rights abuses, or there is a risk that the assets that are returned are stolen again. In these kind of contexts, in these kind of cases, the governments of the assets recovery process in the destination and origin country can or cannot be involved, and usually the assets that are returned are used for a specific project that are, for example, social projects. Typically, they involve higher mechanisms of supervision and safeguards for anti-corruption and to increase transparency. But there are some lessons learned, so I want to share those too in a second. We identified in our research 3 different types of indirect returns through multilateral organizations, which is probably the most common case, for example, through the World Bank or UN agencies, through newly established mechanisms that have been created especially for the purpose of the return, and finally, which is a new interesting development, the involvement of civil society as a third party. I mean, these are just 3 categorizations that we draw from our research, but it should be said that we saw a lot of different cases, different variations. So it's I think this is useful just to understand what are the advantages and disadvantages of these cases. Here are some examples that we analyzed. I'm going to briefly mention some of them: Kazakhstan, Nigeria, Equatorial Guinea, and Kenya. I will not focus on Equatorial Guinea, since we heard a lot already a bit about this from Tutu, and we can discuss it, of course, in another occasion because of time. I want to start with the first type, which are these special mechanisms that are created usually through negotiations or through through a court decision in the country of where the assets are stored, and these are institutional arrangements that are temporary and established exactly with the purpose of returning the funds. They can also involve international organizations, as the World Bank again, or others, and they usually work outside the regulatory framework of governments involved. The most famous case here is the Kazakhstan Bota Foundation case, which ran between 2009 and 2014. This involved the return of $115 million and involved indeed the creation of a special foundation through the agreement of 3 governments involved, the supervision of the World Bank, and the involvement of 2 civil society organizations. This case has been researched, analyzed a lot, has been seen as a best practice in many ways. Here, because of time, I just want to mention some highlights, including the fact that it had some quite strong anti-corruption structures in place, and it involved civil society, although not in the decision-making process itself of creating the foundation. It should also be said that it had some quite high administrative and financial costs, and this is also probably why the foundation was eventually stopped after the dispersal terminated. Going ahead with the second kind, as I was saying, this is probably the most common one, and I would assume the Fondo Social also falls under this category because it foresees the involvement of UN agencies. The role of these agencies can be quite different. They can supervise the return of the assets, as it happened in Nigeria. They can be part of this establishment of this new mechanism, as I was saying before in Kazakhstan, or they can receive the assets and use them for social purposes. I want to focus here on the one case example in Nigeria, which belongs to the third kind, where the World Bank was involved to carry out a cash transfer program to alleviate poverty of Nigerian citizens. This was conducted between 2016 and 2022, so quite recent. It involved a return of 320 million from Switzerland. The decision to create this kind of structure was made by a Swiss court, so this is also important to note in terms of how these kind of structures are built. The most interesting part here, I would say in this case, is the involvement of civil society as a monitoring actor. This was done by a Nigerian civil society, also a partner of ours and of many NGOs here, ANIJ. They were tasked and through a UK development aid project to monitor the dispersals of these funds, and they actually made a lot of reports about how things didn't work out, how about the lack of access to information, but it was an important example of how civil society can be involved in general in asset recovery, but also in engaging citizens in the process, because up to, I believe, 500 people throughout Nigeria were involved to conduct the monitoring. To conclude our brief overview of types of returns, this is the new one that I was mentioning about involving international organizations. Here, these are usually contracted at the national or international level, and the only case that we are aware of at the moment is a very recent one involving Kenya and Jersey, a return that has been announced, but I think the assets have been returned but not used yet. In any case, it involved the assignment of the distributing or using the assets to two international civil society organizations, and the framework also has some important anti-corruption measures. At the same time, there have been some limitations, and also we are also looking a lot into this case and struggling to find information. So still working on it, but still interesting to look at this kind of structure. So this was just a very quick overview of cases. Of course, we can talk a lot more about them, but I wanted to draw some lessons from the past and present cases on asset returns in this context. And here are some advantages of how asset returns involving third parties can be useful. First, they can, or potentially at least, increase transparency and accountability of return processes and how the assets are used. However, we want to stress here that it's not automatic, that just because a third-party agency is involved, this increases transparency. There have to be clear agreements and measures in place for that to happen. However, compared to a direct transfer of assets from one country to the other, the possibility to oversee and guarantee transparency, of course, are increased. And linked to this also the risk of corruption of the assets returned being stolen again, which we have seen actually in the past decades happening. Unfortunately, in asset recovery is decreased a little bit through these kind of structures. And this is because often these third-party agencies have their own mechanisms, their own guidelines, and have capacity to conduct to monitoring and disperse assets in a more transparent way. And finally, probably through a third-party engagement, the civil society, as we have seen in some examples, can be involved, or at least there is more likelihood for civil society to be involved. There are also important considerations on challenges and limits on these kind of structures. First of all, conditionality, which is a huge topic in asset recovery in general. This means basically conditions that asset destinations, meaning countries where the assets are stored and confiscated, are posed on the other country, on the other party, on how these assets should be used. Often countries of origin or where the corruption took place claim that this is a breach of sovereignty of the other party, and therefore refuse these conditions. And so it needs to be carefully discussed how these conditions are agreed on, and that they benefit the people of the country of origin. The other point that I want to make here is the higher administrative costs and financial costs of these kind of structures, of course, involving big organizations or third parties in general, like the UN or other organizations, has a lot of additional admin costs, especially because you need to put in place higher or stronger mechanisms of safeguard, for example, audits, reporting, and so on. And linked to this is also the last point about sustainability. These kind of structures usually are built for the purpose of returning the assets, but what happens with the projects that they fund? Are they going to continue? And therefore, this is also an important limit. Finally, the process of selection of independent organizations is also an important part of this whole discussion. Whether it's an NGO or an international organization, what are the criteria to choose the right party? And in some cases, we have seen negotiations at closed doors, so the two countries or more countries involved were just deciding without anybody knowing what was happening and why the decision was taken. So this is also a risk, and at the same time, civil society also needs to be, of course, selected in a transparent way. So these are some challenges that I wanted to mention. To conclude my overview, I want to talk briefly about good practices and recommendations on how to establish a mechanism for return of assets involving third parties. First of all, I think it's worth reflecting on why it's useful to have this kind of setups, because of their costs, because of all the complications. So this means also considering cost-benefit analysis, an analysis of the rule of law in the destination country, and other kind of analysis that can help to figure out what's best, especially versus a traditional kind of recovery. And as I was saying earlier, the selection process of the type of organization is also important to take into consideration the specific needs, the capacity needs of the organizations involved, and transparency and accountability mechanisms. And this is actually where I wanted to conclude my presentations, some of the outcomes of our research and what we think are some minimum requirements that are needed in this kind of asset returns. First of all, a quick overview of the international framework of this. I think it's fair to say that the international community or international law doesn't have very strong obligations, just new recommendations, quite recent ones that were developed in different frameworks. For example, the Global Forum on Asset Recovery, which took place in Washington in 2017, or the African Union Common Africa Position on Asset Recovery. So these are just recommendations for states to take into consideration transparency and accountability into their asset recovery discussions. Finally, there is also the civil society principles for accountable asset return, which we developed as civil society, as a consultation with a lot of different NGOs, where we established minimum requirements for transparent return of assets. And here are some examples of what these minimum requirements are. In terms of transparency, for example, we think that it's important to publish timelines, modalities, and actors involved in the asset recovery process. We also ask authorities to publish audited and reports in an independent way, and also periodically, and also ensure that there are systems in place for the public to be able to trace the assets. And finally, also negotiation agreements such as memorandums of understanding should also be made public. Regarding accountability, I think these relate to a lot of anti-corruption areas, but we think that asset return processes and the involvement of third parties should include open negotiations, the publication of tender results, and publication of conflict of interest policies to be made available to the public. And regarding integrity, that is also an important part to avoid corruption instances in the return processes, that there are contractual obligations in the agreements to exclude the authors of the corruption, of course, and other beneficiaries, and that process includes investigations by the destination countries and the other countries, so that the disbursement is stopped when a corruption case happens. And in general also available and independent reporting mechanisms. To conclude, just last slide, I wanted to mention the role of civil society here, because we are talking a lot about this today. There is enough evidence to say that civil society has had a successful role in making asset recovery more transparent and more accountable. At the same time, civil society is uniquely placed to represent the victims of corruption and to identify what are the most important areas where the assets return can contribute. In order for this to happen, we think that civil society should be involved from the start of the asset recovery process, including in the negotiation phase, which has unfortunately not happened almost any time, at least according to our knowledge. At the same time, that the role of civil society should be formalized and is decided collectively, whether it's monitoring, managing funds, and decision on making process on how to use the funds. Of course, if needed, civil society should be granted resources to build their own capacity on such a quite complex topic, such as asset recovery. And finally, of course, to be also accountable ourselves to apply transparency and accountability criteria also to involve CSOs.